my previous posts, I looked at the issue of protecting your blog content and also your blog identity. This one briefly looks at some of the issues concerning the inclusion of other people's materials in your content. As I mentioned in the last blog, as a blogger, you need to look in both directions when it comes to intellectual property or IP. In particular, you should ensure that what appears on your blog, be it text, photos, or comments, does not infringe the IP rights of someone else before you actually launch that blog with your new blog identity. You should carry out trademark searches to make sure that your name, tagline, and logo don't infringe the registered trademark rights of another person or company. Public domain and copyright. Moreover, make sure that the contents of your blog presence don't infringe someone else's copyright content, because content isn't in the public domain just because it's freely available to access on the internet. This is a trap people often fall into. So unless you created the content yourself, for example, taken that photograph yourself, you cannot assume that it's not protected by copyright. So in fact, you should always assume that any content that you want to use is protected by copyright, and that copyright will only expire 70 years after the death of whoever created it. While it's true that there are exceptions which permit some sort of use of protected material, fair dealing in the UK or fair use in the United States, these are really limited in scope, as you'll see in a minute. So use of stock images, these days with search engines like Google, there are thousands of images online for bloggers to use in their blogs. However, make sure that your use won't infringe copyright by checking the terms of the sites that you're using. Do the license terms actually cover your blog? For example, if you may only make non-commercial use of something, do you have promotions and otherwise make your blog pay? Then don't download from a site that only allows non-commercial use, as doing so may well amount to unauthorized reproduction, which would be contrary to copyright law. Fair dealing of copyright material. Now, what happens if, as a blogger, I want to use material such as photos from a news event, or if I want to quote from an existing article or book, or even if I want to parody such material? Well, assuming that the content that you want to use is protected by copyright, which, as I've said, is likely to be the case, the general position, at least in the UK, is that the reproduction of a substantial part of a work amounts to copyright infringement. What constitutes a substantial part is complex and a large topic, and will differ in each case, as everything depends on the particular facts. So let's not get bogged down really here with the somewhat tricky issue of what amounts to a substantial part, and instead let's look at what the law actually permits by way of certain limited exceptions which constitute fair dealing in the UK. Although there are a number of fair dealing exceptions, as I've already mentioned, only a few are likely to be relevant to bloggers. These include criticism and review, parody and quotation, secondly, reporting of current events, and thirdly, incidental use, which is not strictly fair dealing, but convenient to actually mention here while we're talking about it. If you reproduce part of a copyright work, let's say an online article, in order to criticize or review that work or another work, then your use may qualify as fair dealing under the laws in the UK. This same law also protects you when you feature a quotation of a work. However, it's important to actually note that you may not freely reproduce a work if you want your use to be fair. So reproducing an entire article on your blog is unlikely to be fair dealing. And the exception applies only to published works. Moreover, you must normally also include a sufficient acknowledgement of, the original work. The law in the UK also provides for fair dealing of third-party copyrighted material for the purpose of reporting of current events. However, photographs are excluded completely from this exception, and so you cannot download and reproduce a photograph, for the purpose of news reporting on your blog. While it might seem obvious, the actual events must also be current, and you must normally include a sufficient acknowledgement. A blogger may also make incidental use of somebody else's copyright work without infringing copyright in that work. However, the law in the UK expressly excludes the deliberate inclusion of another's music or lyrics. So, for example, you cannot add a song in the background of a video clip and claim that your use was incidental use if the song owner, for example, objects. It is not incidental use in this example because the music was actually specifically and deliberately added. Creative Commons licenses. Now, the last decade has seen the rise of open access forms of disseminating works, known as Creative Commons, or CC. Now, these provide for standard form licenses, allowing members of the public to reuse a work in particular ways. Creative Commons licenses have sought to develop basically a suite of licenses to give permission on use of certain types of work. So the menu of terms and use content are all explained on their website, and they only allow reuse in unmodified form. So only reuse with attribution. They allow only reuse often for non-commercial purposes. So although they're extremely popular in recent years, the most common kind is the attribution non-commercial, non-derivative works license, which effectively means they're not suitable for bloggers because you can't reproduce, distribute or play the work in a non-modified form in non-commercial context. A blog will actually be using it in a commercial way. So CC licenses are better suited to users who do not seek remuneration from copyright. Using other people's logos or trademarks. Now, a question that often arises is to what extent people can actually include the brand logos or trademarks of others in blog content. In terms of logos, say logos of famous companies such as Virgin, Barclays, or Coca-Cola, the best advice is don't, because use of most people's brand logos is usually protected by both trademark registration and copyright. This means that any reproduction by you on your blog of somebody else's brand logo is potentially copyright infringement. In contrast, the mere reference in your blog to a word trademark, such as, for example, Barclays or Gap, is unlikely to amount to trademark infringement. This is because use, generally speaking, of names do not enjoy copyright, and trademark infringement is based on consumer confusion, and so a mere reference to Barclays or Gap or whatever the brand name is not necessarily going to confuse your readers. That said, if your use is such that the relevant consumer might be led to believe that your blog is somehow connected or supported by Barclays Bank or Gap, then your use could potentially amount to trademark infringement. So, when in doubt, stick to merely referring to their brand names and avoid using others' trademarks in such a way as to cause consumer confusion. Now that you have some basic insights into the IP laws, happy blogging!